Welcome students. Next topic of module 5 is Environmental Protection Act. Protecting and conserving our environment is crucial for every subsistence and development of human race. The Parliament of India has enacted certain laws for the protection and preservation of the environment, which helps in the sustainable development of the country. The decline in environmental quality has been evidenced by increasing population, loss of biodiversity, excessive concentration of harmful chemicals in the atmosphere, lithosphere, hydrosphere, and also in food chains. Growing risk of environmental accidents and threats to life support system. Various laws related to the protection of environment and pollution have been passed by Indian legislature. However, the EPA, Environmental Protection Act 1986, is the most comprehensive act on the Indian statute book relating to the environmental protection. This act was enacted to ensure the safety and quality of the environment. Under this act, some important points have been included in time, like taking all necessary steps to preserve the quality of environment, to plan and implement a nationwide program for prevention, control, and abatement of environmental pollution. Setting up the standards of environmental quality. To establish coordination in the work of state governments, officers, and the concerns under the acts related to environmental protection. Delimiting the areas where no industry or industrial activities can be established or conducted. There is a provision of severe punishment for those who violate the said act. In this topic, we will cover introduction, various acts, schemes, rules and schedules, objectives and functions, and then penalties. Now the introduction. This act was enacted by the Parliament of India in 1986. It is a general legislation for the protection of environment, and it was passed in March 1986 under Article 253 of the Constitution and came into force on 19th November 1986. This act came into force soon after the Bhopal gas tragedy and is considered an umbrella legislation as it fills many gaps in the existing laws. As the introduction says, this is an act to provide for the protection and improvement of environment and for matters connected therewith. Whereas the decisions were taken at the United Nations Conference on the Human Environment held at Stockholm in June 1972. to take appropriate steps for the protection and improvement of human environment. In this conference, India participated, whereas it is considered necessary to implement the decisions aforesaid insofar as they relate to the protection and improvement of environment and the prevention of hazards to human beings, other living creatures, plants and property. This was due to Bhopal gas tragedy, which was considered as the worst industrial tragedy in India. Now, a scheme of this Act. This Act consists of 26 sections, means dharaएं, and divided into 4 chapters. Chapter 1 includes Section 1 and 2. Chapter 2 includes Section 3 to 6. Chapter 3 includes Section 7 to 17. Chapter 4 includes Sections 18 to 26. There are 7 schedules, means anusuchiyan, dealing with the emission standards of air, noise, effluents, etc. Various rules, including environmental protection, have been framed under this Act. Now, Chapter 1. Chapter 1 includes Section 1 and 2. Section 1 says about title of this Act. It extends to the whole of India and date of commencement in a particular area. Section 2 deals with the definitions, shows a total lack of understanding of the modern concept of environmental pollution and the factors that lead to the imbalance of the ecosystem. Now, Chapter 2. It includes Section 3 to 6 and covers general powers of the central government. The central government have the power to take all such measures as it is necessary for the purpose of protecting and improving the quality of the environment and preventing, controlling and abating environmental pollution. Planning and execution of a nationwide program for the prevention, control and abatement of environmental pollution. The central government may appoint officers with such designation as it thinks fit for the purpose of this Act, and may entrust to them such of the powers and functions under this Act. The central government, in the exercise of its powers and performance of its functions under this Act, issues directions in writing to any person, officer or any authority which shall be bound to comply with the specific directions. So, Section 3 covers powers of central government to take measures to protect and improve environment. Section 4 related to appointment of officers and their powers and functions. Section 5, central government has powers to give directions to the assigned personality. Section 6, central government is authorized to make rules to regulate environmental pollution. Chapter 3 includes Section 7 to 17 related to prevention, control and abatement of environmental pollution. Section 7 relates with no person carrying on any industry, operation or process shall discharge or emit or permit to be discharged any environmental pollutants in excess of such standards as may be prescribed. Section 8. No person shall handle or cause to be handled any hazardous substance except in accordance with such procedure and after complying with such safeguards as may be prescribed. If the discharge of any environmental pollutant in excess of the prescribed standards occurs due to any accident or other unforeseen act, the person responsible for such discharge and the person in charge of the place at which such discharge occurs shall be bound to prevent the environmental pollution caused. Section 10. Powers of entry and inspection allows any person appointed by the central government the right to enter within reasonable hours at any place to inspect, perform the duties entrusted to them, examine and test any equipment, industrial plan, record, register or document. Section 11 provides power to take samples and procedure to be followed in connection therewith. The samples can be collected by the appointed authority. The results of such testing can be submitted as evidence during the investigation. Section 12 allows the central government to establish environmental labs or declare existing labs as environmental labs. Such labs carried out the testing of sample pertaining to any investigation under this Act. Section 13 and 14 says the appointments of government analysts and generate reports of the concerns. Section 15, 16 and 17 outlines the penalties of non-compliance. If the offense is committed by a company, the company as well as the director, officer in charge, and any other relevant personnel is liable to be held guilty under this Act. If the offense is conducted by a government department, the head of the department and any other relevant officer shall be held guilty. This section also says that a case cannot be filed if the government entity or an officer of the government did actions under good faith. Chapter 4 includes miscellaneous part of this Act. Section 18. No prosecution or other legal proceedings shall lie against the government or any officer or other employee of the government constituted under this Act in respect of anything which is done or intended to be done in good faith in pursuance of this Act. Section 19 says cognizance of offences. Section 20. Information, reports or returns. The central government may, in relation to its function under this Act, from time to time require any person or other authority to furnish to it, or any prescribed authority or officer, any reports, returns, accounts and other information, and such person or other authority shall be bound to do so. Section 21. Members, officers and employees of the authority constituted under Section 3 to be public servants. Section 22. Bar of jurisdiction. It is an important part of the Act which prevents any Indian court to take up a case or prosecution against an officer who is doing his duty to uphold the laws under this Act. Section 23. Without prejudice, the central government can give powers by notification in the official gazette, subject to such conditions and limitations as may be specified in the notification, such of its powers and functions under this Act as it may deem necessary to any officer, state government or other authority. Section 24. Where any act or omission constitutes an offence punishable under this Act and also under any other Act. The offender found guilty of such offence shall be liable to be punished under the other Act, not under this Act. Section 25. It gives power to make rules. The central government, by notification in the Gazette, make rules for carrying out the purpose of this Act. Section 26. Every rule made under this Act shall be laid before each House of Parliament while it is in session for a total period of 30 days, which may be comprised in one session or in 2 or more successive sessions. Now the schedules of EPA means Environment Protection Act. Schedule 1 enlists the standards for emission or discharge of environmental pollutants from the industries, processes or operations and their maximum allowable limits of concentration. Schedule 2 gives general standards for discharge of effluents and their maximum limits of concentration allowable. Schedule 3 enlists ambient air quality standards in respect of noise and its maximum allowable limits. Schedule 4 having standards for emission of smoke, vapor, etc. from motor vehicles and maximum allowable limits of their emission. Schedule 5. Furnishing of information to the authorities and agencies. Schedule 6. It gives information about general standards for discharge of pollutants. Schedule 7 is inserted for National Ambient Air Quality Standards. Now the objectives and function of EPA. To provide protection and improvement of the environment, to prevent environmental pollution in all its forms, to tackle specific environmental problems and pollution control that are peculiar to different parts of the country, to coordinate the activities of the various regulatory agencies already in existence, to appoint environment officers to check environmental pollution, to improve the quality of life by protection of environment and establishing environmental laboratories, to protect the forest and wildlife in the country, to conserve fossil fuel reserves by using alternative energy resources, biological control of pests using natural predators to eat them instead of pesticides, set aside lands for animals to prevent overgrazing and destruction, to lay down standards for emission or discharge of environmental pollutants from various sources whatsoever. Now the penalties. Section 15 outlines the penalties of non-compliance. The penalty for the contravention under this Act is imprisonment of 5 years or fine of ₹1 lakh or both. Failure to comply with this punishment will result in a further penalty of 5,000 per day, followed by an extended imprisonment of 7 years. If the offence is committed by a company, the company as well as the director, officer in charge, and any other relevant person is liable to be held guilty under this Act. If the offence is conducted by a government department, the HOD and any other relevant officer shall be held guilty. The HOD can be exempted if he or she can prove that the offence took place without their knowledge, or if they can prove that they did their utmost to prevent the offence. The section also states that a case or prosecution cannot be filed if the government entity or an officer of the government did actions under good faith.